Hello, good evening to you all, and thank you for coming all the way up to the 32nd floor of the building in which Reed Smith resides. For those that don't know me, I'm Nick Austin, and I'm very firmly wearing two hats tonight. One as a partner of the shipping team in Reed Smith, and one as a member of the Council of the London Shipping Law Centre. And it's in those two capacities that I want to extend to all of you in the room here, a very warm welcome indeed. And to those of you joining virtually in the Zoomosphere, also to welcome you as well to tonight's LSLC event. We have a fascinating topic ahead of us this evening in limitation. And to do it justice, a chairman and speakers of the, I would say, very highest caliber. I'm sure they would say that too. And the theme is know your limits, who, what, where. And our speakers tonight are going to pick up on some recent decisions dealing with those important questions. Before I hand over and introduce tonight's chairman, I think each speaker will speak for around 15 minutes, depending on how strict the chairman decides to be on that. Thereafter, there will be time for some Q&A. And just on the technological side, those of you who are joining us virtually, most of us are obviously all well known to each other, both in the room and virtually. If you would like to share thoughts amongst yourselves, please use the chat function on Zoom, which I'm sure most people will be very familiar with. That won't be monitored here in the room by the speakers or by the chairman. But if you want to ask a question for the Q&A session, or hope to ask a question, depending on the time that we have available, please do put that in the Q&A function, which users of Zoom, all of us by now will know is slightly different. So do please put your questions in the Q&A, and our chairman will have access to those. And depending on the time, we will hope to address as many of those as possible. Thereafter, there will be in this room, anyway, for those here, some drinks and canapes just outside, after we finish at around, I don't know, 10 past 7, 7:15. So that is the running order. I'm not going to introduce the speakers because that's going to be left to the chairman, but I will, of course, introduce our chairman, who really needs no introduction at all, but I will give one anyway. Mr. Justice Andrew Baker, well known to all of us, became one of the judges of the Commercial Court in 2016, authorised to sit in cases in the Financial List and the Administrative Court in the King's Bench division, as of course we now know it. Educated in Strathclyde in Scotland before reading maths at Oxford, called to the bar in 1988, and from 1989 practiced at 20 Essex Street in a commercial lit shipping and arbitration role. Appointed QC in 2006 and was Admiralty Judge appointed in 2020 upon the retirement of Sir Nigel Tier. He's also, as many of you will know, the co-author of Time Charters, 7th edition, I should say, 2014. So without further ado, I'm going to pass over to Sir Andrew Baker, who's going to start us off.
Nick, thank you very much. It is always a pleasure and a privilege to accept an LSLC invitation to chair one of these sessions. A pleasure because I get to do very little work in comparison to all the work done by our speakers in preparing their presentations and being ready to field your fiendishly tricky questions at the end. A privilege because I certainly felt this when at the bar. I still feel this when now coming to these events as a judge, either because I've been asked to chair or because I've been able occasionally to simply attend as a delegate. I do take the view that the LSLC usually manages to put together a seminar format event that is of the highest quality, and I hope that tonight will live up to that high expectation. Certainly the quality of speakers that LSLC have invited to speak to you would suggest that it should do so. On the theme of the years flying by as you get older, I can't quite believe that it is already just over 2 years since I have been Admiralty Judge. if there has been a slight theme by way of the cases coming up in what is, I confess, a relatively light list compared to what one might have to run if in charge of the commercial court or one of the other bigger lists in what is now the King's Bench division. But if there has been a theme, it has been interesting issues arising in the law of limitation. Indeed, I reminded myself for this evening that in the Admiralty Judge update in the Commercial Court report for 2019-2020, I said that the most significant Admiralty cases in 2020 concerned limitation and collision. In relation to collision, that was more to do with how Sir Nigel, my predecessor, had coped with the Sakazaya Calon being required for trial just as the first lockdown of COVID hit. But as regards limitation, I said there was a focus on who can limit. Steamer Barge 2, who is a barge operator, and the Holyhead Marina case, a lessee of a floating pontoon, is that a marina area or how else does it qualify? Now, that was 2019-2020, and just in case you were thinking that makes this all rather old news, and if online you were thinking of seeing if you could watch a quiz show instead, both went to the Court of Appeal, and we have had decisions, therefore, since one in November, I think it was, one in December of last year. So the Court of Appeal have marked Sir Nigel's homework in those two cases, and as we shall hear with, so far as Sir Nigel was concerned, mixed results. And the third case upon which we're going to focus tonight is one of mine from earlier this year, and I'll leave you to judge whether it is more daunting for a judge to have their homework marked by the Court of Appeal or by the global head of the Reed Smith Casualty Admiralty team, because that is what lies in store for my judgment this evening. That brings me on to our speakers. I reckoned, if my arithmetic is correct, I did once do a maths degree, but that doesn't necessarily mean I can count. Our speakers between them have an aggregate 81 years of specialist shipping litigation experience as qualified litigators at the bar and as a solicitor. And of course, in Richard Gunn's case, that comes on top of 17 years commercial experience, 12 at sea, ultimately as a fully qualified master mariner, and 5 on shore, running, I think it was a tanker fleet. Sorry. So you could not want for a greater level of experience and expertise. I have known our first speaker, Chirag Karia, King's Counsel, as he now is, literally for all of my professional life, as we studied together for the bar, and in particular sat together in international trade lectures and seminars on bar finals, and we have come across each other over the years ever since. You will know from his biography, which I won't further summarize, that he is at the top of his game as a leading silk in our field. In James Wattay, you have one of the bar's most senior and experienced and expert juniors. At the risk of embarrassing him, you may have noted from his CV, if you hadn't looked at it for a while, it now includes appointment to the Attorney General's A panel. It was a particular pleasure to be one of his referees for that. We do, as judges, quietly keep a scorecard of how well we do when being asked to referee for people. Do they get silk? Do they get appointed to the Attorney General's A panel? I won't say I have an unblemished record, but I would like to think I do fairly well in steering people as to whether it's the right application to make. And I'm very glad to see that James was successful in that. And of course, finally, you will hear from Richard Gunn, as I said already, global head now of the Reed Smith Casualty and Admiralty team. If it has gone bang in the night, Richard or one of his team is likely to be there or thereabouts as part of the investigation or advisory work that follows. You will have seen from the brief biographies that may have been made available to you some of the recent cases, including some of the most significant CMA, CGM, Libra, and the Ever Given jump out, for example. On the theme that limitation has been a theme, I shall say nothing at all about the MSc Familiar, not least because I have it back in front of me in 2 weeks' time for round 2, where we will be discussing matters of what kinds of damage are or are not within the scope of the limitation regime of the convention at all. But for this evening, it's a range of different topics. And without further ado, I will ask Chirag, please, to go first to discuss the steamer barge 2. Thank you very much, Chirag.
Thank you very much, Andrew. Right, I hope everyone can hear me now. Of the 3 aspects of our seminar today, the who, what, and where, I'm going to be dealing with the who. And I'm going to do that by reference to a case that I did from 2000 onwards called the Stemmer Barge 2, which started at first instance before Mr. Justice Tier and then went to the Court of Appeal. So starting right at the beginning, obviously everyone will know that 1976 limitation convention applies in Great Britain, and under English law, it has the force of law. The Article 1.1 of the convention gives the right to limit to ship owners and salvors. Article 1.2 then further defines who a ship owner is, and it means the owner, charterer, manager, or operator of a seagoing ship. So we've got 4 categories there that we will look at. Interestingly, the same people were entitled to limit under the 1957 convention, although the 1957 convention achieved that not by way of definition, but in Article 6.2, it provided that the charterer, manager, and operator of the ship would have the same rights to limit as the owner. So you end up at the same place. Now, the owner is simple enough, and the owner can limit. And besides having to look at part owners and things like that, not much complexity is brought into play. The charterer, that did bring in some contention, because in the CMA Jakarta, Mr. Justice David Steele held that a charterer could only limit if what he was being held liable for, he did in his capacity as qua owner. So he imposed that gloss saying this whole purpose of limitation is to protect the owner, and therefore only if the charterer is acting as an owner or qua owner could he limit. The Court of Appeal said he was wrong and held that there was no gloss to be applied. A charterer acting as charterer, if being held liable, could limit under the convention. And that was taken one step further in the MSc Napoli by Mr. Justice Tier, who held that a slot charterer is also entitled to limit, even though he is not the charterer of the whole vessel, but only a part of it. So we've looked at owner, we've looked at charterer, and then we come to manager or operator. Now, until the first instance decision in the Stemmer barge, there was no authority on the meaning of manager or operator. Now, that's actually quite surprising, given that we've had that phrase for over 70 years in either the earlier convention or the later convention. And indeed, there are over 70 countries that have adopted one or other of the conventions. Now, how do we go about interpreting these provisions in this convention? The Court of Appeal in the CMA Jakarta made it clear that you apply not English canons of construction, but generally accepted international canons applied to treaties, and in particular, Articles 31 and 32 of the Vienna Convention on the Law of the Treaties. Now, actually, that gets you quite similar to English law, because what those say is you apply the ordinary meaning in the light of the object and purpose of the convention, which sounds very familiar. There is, of course, a recourse to travaux préparatoires, but the Vienna Convention says you should only do that to confirm a meaning that you have already established based upon the ordinary meaning of the words used. Now, we'll see in the Stemmer Barge 2, the Court of Appeal, with some encouragement from me, used it on a wider basis to confirm what we were arguing. Now, as regards operator, there's an interesting decision called ASP Ship Management versus Administrative Appeals Tribunal from the Federal Court of Australia. And the whole question in that was, what does to operate mean in an Australian statute insofar as it relates to a ship? And the Australian court pointed out, first of all, that to operate or operator can be understood in various different levels of abstraction. So you can refer to the physical or commercial dominion or of the enterprise. So you're having the control of the enterprise that the ship represents, which is management and commercial control. Or you can refer to the operation of the actual machinery, the engines and all the other paraphernalia of the ship itself. And here you'll see is where the difference between the first instance judge and the Court of Appeal came into play. So what were the facts of the Stemmer Barge? The facts were that Split Chartering, they were the owners of the barge. It was a dumb barge, and it was operated by Stemmer AS, a related company. And Stemmer UK was also a related company. And as a result of a severe storm, rock armor had to be purchased and used to repair the railway line above Shakespeare Beach between Dover and Folkestone. So rock armor was imported from Norway. It was sold by Stemmer AS to Stemmer UK. The barge that it came in was owned by Split. It was operated by Stemmer AS, and Stemmer UK had nothing to do with the barge until it came off Dover. When it came off Dover, employees of Stemmer UK went on board, released her anchor, and started discharging the cargo. And they did that by transshipping it onto a smaller barge. In addition to doing that, given that this was an unmanned barge, they also did various things to keep the barge safe. So checking its navigation lights, generators, and towing wire, and adjusting its ballast as they were discharging the rock armor. Crucially, or at least importantly, there was no crew on the barge. It was a dumb barge. So the only people looking after the dumb barge off Dover were Stemmer UK's employees. Now, during Storm Angus on the 20th of December 2006, the barge dragged her anchor, and that anchor cut one of the high voltage electricity cables coming from France to England, owned by my client and HFW's client, Réseau de Transport d'Électricité SA, or RTE. Now, as a result of that cutting, RTE suffered around 37 million euros of damages for repairs. Or these are the sums which will obviously be subject to proof in due course, and 17 to 18 million in consequential losses. So we're looking at about 54 55 million euros. Now, as you would expect, Split, Stemmer AS, and Stemmer UK commenced limitation actions, and we, the end, accepted the right of Split and Stemmer AS as operator to limit, but we disputed Stemmer UK's right. Now, Stemmer UK said, well, we were the barge's operator, or alternatively, the manager. So what did the judge decide? The judge, first of all, had to determine what manager meant. And well, that's the route he took. He gave a slightly circular definition. A manager was somebody who was entrusted with sufficient tasks of ensuring vessels' safe operation, manning, maintenance, and profitable employment, so as to be called a manager. But it makes it very clear that we're looking at the higher level work. We're not looking at the actual physical work of the ship. And early in his judgment, he also said operator had to be construed at a higher level of abstraction. But he also held that although Stemmer AS was the general operator of the vessel, given that there was nobody available off Dover, during the 14 days that the vessel was in Dover or off Dover, Stemmer UK was its operator. And I've quoted here what he said about the ordinary meaning of operator, and he didn't seek to define it, but he simply said that it embraces not only the manager, but also the entity which, with the permission of the owner, directs its employees on board the ship and operates her in the ordinary course of the ship's business. Now, it wasn't clear from the judgment. If you read the judgment, in some places, he has a general statement like that. In other places, he refers particularly to the fact that the barge was unmanned. He also was influenced by the fact that Stemmer UK was a related company of the two other parties who we accepted were entitled to limit. And he said it would not encourage the provision of international trade by sea carriage if the owner could limit its liability for the loss and damage, but the associated company which operated the barge at the discharge location could not do so. So we asked for permission to appeal. He refused. He thought that there was no real prospect of us succeeding. Luckily, we got it from the Court of Appeal. And we argued that operator had to be construed and understood at a higher level of abstraction. It isn't sufficient that you simply operate the machinery or you provide the crew that operates the machinery. And we relied on the travaux préparatoires and on Article 1.4 to show that that meaning is inconsistent with the general scheme of the convention. And the travaux préparatoires showed that there were various efforts to insert additional categories of people entitled to limit, including those providing services in direct connection with the operation of the ship, and those were all rejected. And we said, if Stemmer UK did anything, they provided services in direct connection with the operation of the ship, and the travaux préparatoires shows that that was not they were not somebody who was entitled to limit. We also relied on the judge placing too much reliance on the barge being unmanned, looking at too short a period of time, and being impermissibly influenced by the fact that the three companies were related. So what did the Court of Appeal decide? Firstly, following the ASP Australian case, they held that operator can be interpreted at several levels of abstraction, and that a higher level of abstraction was appropriate in the convention. They pointed out that a ship is a commercial enterprise requiring interrelated operational responsibilities, and that merely operating the ship's machinery or providing the ship's crew was insufficient. What was required was management or control of the vessel. Otherwise, Article 1.4, which gives the right to limit to employees or people for whom the people who can limit are liable, would be superfluous. And also the decision of the judge was contrary to the clear intentions of the contracting parties in the travaux préparatoires. They also did not accept that the fact that the vessel was unmanned made a difference. Either you had to construe operator at a higher level of abstraction or you didn't. And once you've decided that you have to construe it at a higher level of abstraction, the fact that there was no crew, so somebody else had to provide the crew to do the physical operation, did not allow a different test to be applied. They also said that the judge had wrongly extended protection to associated companies because those were not a category within the convention. And the point I made is companies and groups of companies organize their affairs and create companies in order for as they see their own benefit. They've got to take the benefits and burdens alike. You can't say we are separate companies for purpose A, but when it doesn't suit you to say, oh, well, no, but we're all part of the same group, really. So the Court of Appeal reversed the judge's decision, they held that STEMA UK was at most they provided services. They did not become a second or alternative operator. One additional point and final point is even though the convention refers to the operator or manager, you can have more than one. The Court of Appeal has made clear. But the court should be slow before concluding that there is an additional manager or operator. There needs to be proof to establish that. And it wasn't enough that for a very short period of time, they were providing services to operate the vessel. The respondent's notice on the manager was dismissed, and in fact, neither decision really gives you much guidance on the manager, although Mr. Justice Tier's decision gives you more guidance, telling you that it's a more commercial aspects that you're looking at in order to constitute a manager. So that is a quick whistle stop. I hope I've stayed in time. I'm sure I will be told if I haven't.
Chirag, thank you very much for that. Well, more than I would suggest whistle stop to a rather comprehensive and yet to time summary of the STEMA Barge 2. And that means we move from the who to the what, although the what on one view is another aspect of the who. It's what is source for the goose is also, as you know, the phrase has its source for the dock owner, as James will remind us. It may be that we have squeezed that into the snappiest title of who, what, and where, but others can comment on that. Before I do hand the floor to James, and in the hope that this is not an indication that all of you watching online have merely been stunned into silence by the brilliance of Chirag's presentation, do remember that if there are particular questions, either to explore what you've heard further or to test the limits of what you have heard, do, if you're watching from home or the office, put those questions in the Q&A function, which I will try to keep my eye on so that I can pass those to our panelists. But we'll take questions on all of the speakers' topics at the end. And therefore we move to the what, the Holyhead Marina, and James. Thank you very much.
Thank you. And yes, you have seen straight through us in our attempt to squeeze ourselves into a snappy title. But I am actually dealing with the what in one sense, which is I'm dealing with the rights of dock owners to limit their liability. And the question I'm dealing with is what is included within the definition of a dock. And the specific question I'll be dealing with is a marina, or can a marina be a dock for the purposes of limitation? Now, Chirag has taken us through already the general principles of interpretation of the convention and by extension English statutes. So I'm not going to go over that again. But what you do need to know is that the source of the dock owner's reciprocal right to limit is nothing to do with the convention, although it's given current effect in English law by the same piece of legislation, the 1995 Merchant Shipping Act, as the convention is. Rather, it comes from this piece of legislation, the Merchant Shipping Liability of Ship Owners and Others Act 1900, a purely UK piece of legislation, which has an interesting piece of a bit of history from another time in the life of this country's commercial life. In late Victorian times, both ship owning and docks were a growing part of our economy. Photograph there is part of Glasgow docks, which was built up around 1900. I'm told that at least half of that has now been filled in and replaced with flats. As I say, a different time and place. But the bill for this act proposed that there be a huge extension to the rights of ship owners to limit their liability. And for the first time, they were entitled to limit their liability for all damage caused to land facilities as well, including port facilities. Now, you can imagine that the owners of docks were rather miffed by that idea, or at least were not willing to go quietly unless they got a reciprocal right to limit for any liability that they have towards the owners of ships damaged in their docks. In fact, a number of MPs and peers who represented port cities and the interests of the trade sponsored the amendment to the bill after a deal was done between the dock owning trade, the ship owning trade, and approved by the Board of Trade. It's all set out in Hansard. I'm obviously not going to go through all of that, but suffice to say, a deal was done and Parliament rubber stamped it. The only express reason for that deal was about fairness and reciprocity. If they're having their liability limited, we're having our liability limited. It does so happen that just as with ship owning, it's likely that giving this right to dock owners did help that trade develop, not least because the related insurance markets were able to have greater certainty and therefore to offer better price cover in light of reduced liability exposure. Now, I hope that's legible. You can obviously read it at your leisure when you get the slides. Liability for dock owners, or the limitation thereof, remains purely a matter of UK legislation. The 1976 convention only limits liability for ship owners and managers, operators, etc. Section 191 of the Act has effectively reprinted what was Section 2 of the 1900 Act. And what it says is, in short, that the owners of any dock, also Harbour Authority or Conservation Authority, will have their liability limited in subsection 2. It says that liability is by reference to the largest UK ship that has been within the relevant area within the last 5 years. And then in subsection 9, the word dock is partially defined. It's not strictly a definition. It's a list of things which are included within the word dock. So it includes wet docks, basins, tidal basins, locks, cuts, entrances, dry docks, graving docks, gridirons, slips, quays, wharves, piers, stages, landing places, and jetties. There was no update to that list in 1995, despite the increasing importance of the leisure marine industry to this country's GDP. One might have thought that the ROAA, British Marine, Holland liability insurance markets might have wanted to either have the position of either have mariners expressly included in that list or expressly excluded from them. But that didn't happen. And instead, it took another 25 years until the courts were asked to determine whether the owners of marinas, swing moorings, floating pontoons, and such like, what we might call leisure mooring facilities, are able to limit their liabilities like commercial dock owners. Now, this is sort of complicated, at least the first time you do it, but the answer is quite simple. At least when we're talking about marinas, you're almost certainly going to have a liability cap of 500,000 SDRs. And that's for two reasons. Firstly is the cross-referencing process I've set out on the slide, which basically tells you that for small vessels, you have to substitute the figure 500,000 SDRs for the usual limited amount. At 300 tons is the limit under which you get to 500,000 SDRs, and almost everything you have in a marina, it's obviously going to be quite a lot smaller than that. It makes it in today's money, and I should say this is quite a bit more than it was last week. 500 SDRs is around £587,000. Now, it made no difference. It makes no difference how big the marina is, whether there are 10 boats in it, 500 boats, and it makes no difference what the value is of the boats, even though all these things are clearly relevant to the potential loss. Oops, excuse me, you don't want to see that yet. So can a marina owner limit? Well, to answer that, I'll need to talk about a case which I did between 2019 and this year, or actually the very end of last year. I was before Mr. Justice Tier and led by Nigel Cooper in the Court of Appeal. I was for the boat owners and their insurers. Ben Coffer and in the Court of Appeal, Bob Thomas were for the marina. Solicitors were Dan Cockford of Ince and Emma Rice of Clydes. Now, this was a limitation claim brought by the owners of Holyhead Marina for a declaration that they were entitled to limit their liability for losses arising out of Storm Emma in March 2018. This is a before photograph, and it's made up of floating pontoons. They're secured to the seabed by anchors and ropes, and to each other by flexible fittings. It's connected to the land by a footbridge, which you can see in the bottom left corner, which lay on one of the pontoons it was attached to the land by a big hinge, and it rose up and down as the pontoons fell and rose with the tide. Most of the boats were leisure. There was also a lifeboat, which you can see it on the left, and a couple of wind farm vessels. Now, on the 1st and 2nd of March 2018, Storm Emma arrived. It was part of the series of extreme weather events known as the Beast from the East. This meant that the winds were from the east-northeast, which is not the prevailing wind in Holyhead. Therefore, the marina had little shelter. They peaked at around 35 knots, but gusting 57. And as I say, from a direction where there was no protection. By mid-morning, one pontoon had failed. By 6 o'clock at night, the bridge had fallen away. By 9 o'clock at night, the first yacht broke free. And by 3 o'clock the next morning, pretty much every boat was free, colliding with each other, capsizing, grounding, sinking. Some took their pontoons with them to the bottom. Thankfully, the lifeboat managed to get away, but every other boat, 89 of them, was actually or constructively destroyed. You can see the after shot here with some examples of the mess. There's a boat on the land. To the left, you can see lots of sails sticking out the water. On the right, wind farm vessel. There's actually you might even be able to see it. There's a little boat in amongst all of that white styrene where her bow is completely snapped off. And you can see that the pontoons are just half of them floating free or disappeared completely. Total damage to the moored vessels was about £5 million, a little bit more than that. So if the marina could limit, that would be about 10% recovery for insurers and uninsured owners, which there were quite a few, because there were projects taking place in the marina. So the question arose, was the marina a dock for liability for limitation purposes? Just a quick reminder there, that's what the marina was made up: floating pontoons, lightly anchored, linked to the land by a small footbridge, open to the sea with no tidal gates. That's important, as you'll see in a moment. Largely, but not entirely, used by leisure craft, possibly less so. Now, the statutory list has no mention of pontoons, floating or otherwise, or any particular kinds of moorings or marinas. But it is also a non-exhaustive list, as is clear from just looking at it. Dock includes ... So one has to ask at the outset whether a marina would count as a dock on its natural meaning, before then going on to decide whether it is a dock on its extended statutory meaning. And pausing before we go on, because the Court of Appeal challenged my leader to ask what a common sense meaning of these words were. And I wonder what would happen if you did a sense check with your non-lawyer friends and family, if you still have some of those left, whether they would see a conceptual difference between Cowes Yacht Haven and Southampton Container Terminal, or would they see them basically as big and small versions of the same sort of thing? Certainly my brother-in-law said that a marina should not be able to limit its liability, and we'll see if he's right. So dictionary definitions. The OED, obviously usual first call, and Brody is the one at the bottom, companion to ships in the sea, was less helpful. It certainly was not relied upon by the judge. But you might think that these are surprising things to be regarded as key features, but both OED and Brody regard the enclosed nature as a key feature of a dock. An artificial basin excavated, built around with masonry and fitted with floodgates. Brody says a closed basin almost surrounded by quays. Both OED and Brody also emphasize what goes on in the dock, the loading, unloading, and in the OED's case, the repair of ships. There are also some dictionary definitions of some of the statutory list. The most important one, as we'll see, is landing places. OED definition is a place where passengers and goods are or can be landed or disembarked. Now, obviously, crew and passengers can be disembarked at a marina. Perhaps a more accepted understanding of landing place is something like a Thames Clipper pontoon, water taxi stop, ferry terminal, or for cargo operations, a wharf. One might think that's a different concept to a place where boats are tied up for a long time after their crew have departed, and which is effectively what I've called there a floating car park. In terms of authorities to help the judge, there were very, very few indeed. In fact, the only one I'm going to talk about briefly is the humorist. This was a decision of the eminent Admiralty judge, Mr. Justice Wilmer, in which the issue was whether a berth outside a waterside warehouse was a dock. The judge considered it did not fit within a traditional meaning of the word dock, and he relied on the OED definition for that. It was not an enclosed area of water enclosed by floodgates. But it did fall within the meaning of the wider list because it was either a wharf or a landing place. Now, on those facts, that's extremely unsurprising, given that the berth was in fact a place where this was set aside specifically for ships to tie up, load, and unload their cargoes. So, on to the hearing in front of Mr. Justice Tier. There he is. He's, of course, as Andrew Baker's predecessor as Admiralty judge. There is not yet a photograph like this handing over the oar, symbolizing the power and majesty of the Admiralty Court to Sir Andrew, because it's not yet taken place. But the happy coincidence, happy result of that is I could still have this photograph from the Commercial Court website. So there is Sir Nigel looking very much as none of us have seen him dressed in court. Now, he considered these matters with his usual care and genuine interest in the issues. And first, he considered the natural meaning of the word dock. He found that Holyhead Marina did not come within that meaning. He started first with a consideration of the humorous, which I've just shown you. And he said, if a judge is experienced in maritime matters, as Mr. Justice Wilmer considered that a dock was an enclosed space with gates to allow the admission and retention of water, I cannot have any hesitation in accepting that working definition. He also said that that was consistent with the two dictionary definitions, OED and Brody, on which he had been cited. But that was not the end of the analysis. The pontoons were not piers, but he did think that they came within the natural meaning of the word landing place. Now, it's in your own time, I would go away and read, in particular, paragraphs 35 to 39 of Mr. Justice Tier's judgment. I don't have time to do that now. But in short, what he said was that when one comes up to a marina, the crew gets off from being at sea and, in that sense, lands. And therefore, the pontoons which make up the marina are landing places. Although he carefully considered the floating car park aspect, he came to the conclusion that you can be both a floating car park and a landing place at the same time. And there's nothing in the statutory wording that prevents him coming from that conclusion. And so he says, for those reasons, I consider that the pontoons which make up the marina are landing places, and therefore within the extended definition. Now, permission to appeal was granted on that point, not by the judge, but by the Court of Appeal itself. And unsurprisingly, we mostly ran the same arguments again, but also took that last point and said that if the judge was right that each pontoon was a landing place, then we have a possible multiple fund situation. Of course, there are other problems with that argument, which we don't need to go into. But The Court of Appeal dealt with that in a very efficient way. We also said that the market was very surprised by the result, and certainly my clients expressed a great deal of surprise at it. And we were able to put in a witness statement for the Court of Appeal showing that the market was indeed surprised and had been pricing its products on the basis that marinas could not limit their liability. In the Court of Appeal, I think the Master of Royals looked at us in pretty much exactly that expression throughout my leader's submissions. Those who tuned into the YouTube hearing will have seen that the Court of Appeal was rather less sympathetic to the boat owners' arguments than the judge was. The result was really never in doubt once the Master of the Rolls started going. Anyway, the judgment of the Master of the Rolls is very short. Lord Justice Stuart Smith simply agreed with it. Lord Justice Males added a very short observation of his own. And there are 6 very short points, and they really were very short. Firstly, the Master of the Rolls said that although DOC and the statutory examples set out might be regarded as facilities that are generally or even wholly used by commercial or passenger shipping, many of them would equally be used by leisure craft. And accordingly, it was not right to conclude that the right to limit only applied to commercial dock owners. Now, he's thinking particularly, he said, of cuts, dry docks, slips, quays, piers, stages, landing places, and jetties. Secondly, the Master of the Rolls said that the judge's decision was compatible with the ordinary meaning of the statutory examples, and especially the meaning of landing place or stage or jetty. He agreed with the idea that the fact that the marina was used primarily for the storage of boats did not matter. It was still a landing place. Thirdly, as to the point that the marina was made up of several pontoons, the Master of the Rolls went further than the judge and held that the marina as a whole came within the meaning of a landing place. That swiftly dealt with the multiple funds point. Fourthly, he said that it doesn't matter that the statutory list was a creature of its time, because if marinas had existed in 1900, they would have come within the meaning of dock used in that act in the original wording. Fifthly, as to the principles of interpretation, and I made this point at the outset, encouragement of international trade was indeed the purpose of the Limitation Convention, but it was not the purpose of Section 191, was not derived from that convention. All you could say was that it arose from a deal between dock and ship owners, and the purposes of the convention are therefore irrelevant. Finally, as to the market understanding point, Master of the Rolls simply dismissed that and said, well, the market misunderstood the law, as they do. The law was as stated by the judge, and the market would simply have to reprice its products now that it had had its misconceptions corrected. And Lord Justice Males' 4-line judgment, he used the words common sense twice, which probably indicates the level of sympathy with our arguments. But he was, of course, right that Mr. Justice Wilmer emphasised that the statutory definition was to be approached in a way that accords with common sense. And of course, nobody would argue otherwise. Do I have a couple of minutes, or am I over?
You're already overdue.
Okay, well, I will wrap it up there. There was another further interesting point about the area over which marinas exercise their power. Have a look at Mr. Justice Tier's judgment, though, and you'll see the difficulties with that argument. And that's the chart that we use to discuss it. And I'm just going to finish off with this picture, because the next interesting case in the Admiralty Court might well be another limitation claim arising out of that, which I can't talk about.
James, thank you very much. We move then from the what to the where. Where do people seek to limit? What happens if there are competitions potentially between different jurisdictions looking at different aspects of a major casualty? One of those jurisdictions looking at the question of limitation. My final reminder as I pass over to Richard, if you are online and have a question for the speakers for the end, post that so that I can field that and pass it as may be appropriate. I won't say I am inundated as I speak, so I shall, those of you who are live in the room with me, be fixing my beady eyes on all of you to hope that you give the panelists a good grilling in a few minutes. But in the meantime, from the who and the what to the where, Richard, thank you very much.
Thank you. Thank you, Sandra. I was going to look at, and probably still can look at, three issues in this MSC familiar case. The last one is to do with issue estoppel, and thankfully, due to time pressures, I'll probably skip over that fairly quickly. But the first two, I think, are interesting, which is anti-suit injunctions and also looking at Article 14, a point on Article the Article 14, Article 4 defence that we'll see. The Flaminia, you're probably all familiar with the Flaminia, and I've put a photo up there just to sort of remind you all of it, and to give you a bit of background. I can do no worse, of course, than use the perfectly formed summary by the judge in the case on just to give the background to this. So on 14th of July 2012, so 10 years ago, the container ship MSC Flaminia was in the middle of the Atlantic Ocean en route from Charleston, Louisiana to Antwerp, when an explosion occurred in her number 4 cargo hold, leading to a large fire on board. And you can see the aftermath of that in that photograph. 3 of her crew lost their lives. One was never found. The other 2 were grievously injured and died of their injuries shortly afterwards. Hundreds of containers were destroyed and extensive damage was caused to the ship. And as the judge quite rightly said, this was, on any view, an horrific tragedy. The explosion was caused by auto-polymerization of the contents of one of 3 tank containers laden with divinyl benzene, or DVB. And those tank containers had been shipped at New Orleans on 1st July 2012. So that's the sort of background, that's the aftermath. And as we've known since, container fires continue to be very common events, and the losses that arise from them are significant and give rise frequently to limitation issues, notwithstanding that the limitation convention levels have been increased. Just a brief overview then of the contractual regime. I'm sure you're familiar with these processes, who the players are. In this particular case, we have Conti, who are the owners of the vessel, and they had time chartered to MSC, one of the largest container operators in the world. Time charter provided for English law and London arbitration. And MSC will have had a slot arrangement with various partners in there who will have done their own thing, but I've just highlighted what MSC will have done. They will have issued their own bills of lading. I've referred to some of them as other bills, and I've referred to one of them as Stolt, because Stolt were the party that shipped these goods under an MSC bill of lading that subsequently exploded. That gave rise to some serious litigation, and I will here, thank you. So we have the explosion on board. Arbitration was commenced soon after in 2012 under the time charter. And then the various bits and bobs will have gone on, which aren't related. In 2017, the certain bill of lading holders under the MSC bills brought a High Court action against MSC. I mention them simply because if you look at the judgment, you'll see that there were a raft of defendants identified by that commercial court action. In the meantime, there had also been an action in the United States by various cargo interests there, notwithstanding any choice of law clause that might have existed in their bills. And that action was brought against MSC. It was also brought against Conti. It was brought against Stolt, and it was brought against Deltec, who I understand manufactured the particular chemicals. And on the 17th of November in 2017, that judgment gave an issue on causation in the sense that it identified the process by which the explosion had occurred, thereby looking at where it came from. In 2018, the phase 2 judgment came out, 10th of September, in that US action, and it said that the claims against MSC and Conti failed, and in fact, liability rested with Stolt and Deltec, who were liable then for those cargo interests. 2020, 21st of July, limitation claims commenced in MSC. That's this action. That's the one we're now talking about. And in 2021, we start seeing some other actions in relation to the arbitration. So in Award 1, which was just an indemnity point, which was dismissed. I'm not bothered with that here. On the 30th of March, there was Award 2, and we'll talk a little bit about that shortly, where MSC was held liable to Conti for these losses. Shortly thereafter, MSC applied for summary judgment. I see it says discussing, it's supposed to say dismissing, Conti's assertion that there was no right to limit under Article 4. And again, we'll look at how that application works, because that's what this is about. 30th of July, in the arbitration, Conti were awarded damages of around $200 million US. And by contrast to that, the fund, which was established on the 5th of October, was 26.5 million, which at the time, as just been said, was probably about $30-odd million, but now is about $26.5 million. So there we are. Such as the swing of currency as it happens. And who knows, by the time there's actually some payment out, we may well be back to the $30 million at least, let's hope so. Thereafter, then 30th of November, MSC looked for sort of another anti-suit injunction against Conti enforcing that $200 million award, and that is the essence of it, really. So Conti, the owners, have got an award against MSC. MSC have set up the fund, and what Conti want to do is go somewhere else and say, to hell with your $30 million fund, I've got a $200 million claim and I want to enforce that somewhere. And then subsequently there was a cross application for various declarations. And that then brought us into the current position on the anti-suit injunction. It's important, I think, to remember that this was an injunction. It's not an injunction to stop the action proceeding. It's not an injunction about a claim on liability as such. It's an injunction that is seeking to prevent somebody enforcing their award or their judgment. And as the judge pointed out, there have in fact only been 3 injunctions granted to prevent enforcement of an award or judgment, and he was not minded to make this the 4th. So if you were hoping for a surprise, you've missed it. So you'll see that in fact the anti-suit injunction was dismissed, and we'll talk a bit in the next slide and generally on the reasons why that. Why were MSC after this? Well, what they had was a judgment, but they hadn't yet got a decree. There were 2 issues, of course. One, were they entitled to limit, which is the anti-suit injunction and the issue estoppel point. And the other was, of course, that the claims themselves had not been quantified, whether or not they were limitable claims or not. The 200 million, some of that it might all be limitable, none of it might be limitable, and that is the action which I believe is being heard in a couple of weeks' time as to which of those there are. So if there's anybody out there previously typing in a question about what are those claims, I suspect we're not going to be discussing it in light of the parties that are here today. But those are important issues, because there was no certainty as to what the position was going to be. Now, it was referred to as perceived as a difficulty. It was a perceived difficulty that you have an award or a claim for a lot of money, and you don't yet have a certain amount within the fund or a claim against the fund. And in light of this judgment, it may not, in fact, be a difficulty for reasons that become clear. So, Article 13 considerations. The things to remember about Article 13 in the Limitation Convention is that what it says basically that any person that has made a claim against the fund is barred from exercising rights in relation to that, other rights in relation to that claim. And the key phraseology, it seems to me, is, although there are other aspects to it, of course, is claim made against the fund. And I'll talk a little bit about that in relation to Article 12, although Article 12 isn't mentioned in the judgment. These are just my thoughts. I'll just leave them out there for you to pour scorn on or challenge me on. But the thing to remember then is there was no claim against the fund, as I've just mentioned. And it was quite clear that Conti had no intention of making a claim against the fund. They were going to take their chances with their 200 million and see where it brought them. Now, they objected to MSC seeking to compel them to enforce their judgment, their award in the UK. They said, why should we be compelled to do that? And remember, their claims, of course, aren't certain as yet. Some may be limitable and some might not be. And for the unlimitable portion, they could proceed and do that anywhere they liked, presumably. And there wouldn't have been an issue about that. It was asserted that, by contrast, MSC said, well, this was sort of oppressive conduct of Conti, in that they participated and were participating in the limitation action. They were seeking to say, hey, you know, you can't do this, you can't do that, you're not entitled to limit. I've got these claims, some of them aren't limitable, some of them are. And therefore, they were recognizing that limitation regime. But this was essentially rejected as well. And it was found that they were entitled to participate in the action, if only to defend the claims. That was a perfectly reasonable response to a limitation action, to say, well, actually, I don't think these claims are limitable. I want to bring them somewhere else. And why should they be bound by the, if you like, by the timetable and strictures that that have been set up by MSC in that regard? And that entitlement was irrespective of whether they had any intention to enforce against the fund. So it was also so, well, what about the fact that they've submitted to the jurisdiction here? They'd agreed in the time charter to English law. This is part of English law. They were now effectively seeking not to apply it, and therefore one should look further at that. Well, three cases in terms of policy. I skipped the stage, but we got to three stages, three cases, which were looked at, the ICL Vikram. And all three cases, of course, deal with different conventions. If it was the same convention, then we're in the convention and it's clear. So you're only ever going to get an argument that is in relation to different conventions. So there were three aspects of that. The ICL Vikram, different convention, of course, and that, as I understand it, was an application in relation to Article 13.2, which is about returns of securities. So a slightly different point, perhaps. The Western Regent, there were proceedings in Texas, and whether or not that should apply there. And of course, the string of Burgoy's South African actions on limitation, which, if you're short of some nighttime reading, then I recommend them. And they again, they were about actions in South Africa. But here, of course, we have an action in England, but nevertheless, the view was that there was nothing within English law, of course, which prevents the application in foreign jurisdictions, which was the bit that I read out in the previous slide. There was no evidence of any prejudice. There's primarily a timing point, as we mentioned before. There was no decree. There was no certainty as to claims in that sense. And in that way, the application was premature. And it was said that if in fact Conte go and enforce somewhere else, you have whatever you can do there, and you could also come back to the High Court to seek to apply in those circumstances to see whether or not it was right to injunct them in that way. But right now, there was nothing to prevent them to do that, and there was no claim against the fund. Now, the bit that's not touched in the judgment, and which I'll just talk about for a minute or two, was the under Article 12, of course, where I'll say an owner, in its broadest sense, where an owner settles a claim against the fund, he can become subrogated to that and can claim back against his own fund, and that's a fairly common and well-known position. And when I was reading this judgment, what made me think about it was, well, if the issue here is that there's no claim against the fund and therefore there is no bar to an action as a result of that, what about the position where you settle a claim where equally there has been no claim against the fund? Has the owner, by settling that claim, prevented himself, or does this judgment then prevent him from coming back and seeking subrogated rights against the fund for his bit that he's paid? Should he have waited to see whether or not there was evidence of a claim against the fund before he goes off and settles it? Because if that's what this case is saying, then there may be some interesting litigation on that going forward. As I say, that's not in the judgment. That's just my view on reading it, and you can take it or leave it. Article 4, this was also, if you'll recall, that the application was to dismiss Conte's assertion that there was no right to limit. That was dismissed under the issue of estoppel point, which for time reasons I won't go into other than a couple of seconds in a moment or two. But the other point that arose in relation to it was as regards the Article 4 defence. Just to remind you that Article 4 is if a person liable shall not be entitled to limit his liability if it is proved that the loss resulted from his personal act or omission committed with the intent to cause such loss or recklessly and with knowledge that such loss would probably result. Now, in fact, in the judgment, the judge has decided that, bar the issue of estoppel points, then they would have been allowed to proceed with this. They wouldn't have got the injunction they were seeking, or they wouldn't have dismissed that application. So that would have gone, but so it doesn't matter for that purpose, and that dealt with issues on evidence. Nevertheless, the bit that caught my eye again was an aside, which is that this part of it, which was looking at the way the pleadings and the case have been pleaded, was essentially looking at, and it was agreed just for the purposes of the application. I get that. It was accepted that the person liable could have been the head of MSC's dangerous cargo department based in Antwerp. He could be the owner for limitation purposes. Now, I know that that's not what they were saying, but it was accepted that there was a real prospect of success, that this guy in Antwerp could be regarded as having the mind of the owner as regards limitation issues. And that sort of came to me as an interesting acceptance, if you like. I'm not suggesting that either party was accepting it for the purpose of a hearing, but they recognized that there was, of course, an argument in that sense. And it may be that they felt stronger on the other points. They didn't want to take that point. But from my perspective, I've always thought that, no disrespect to the individual, but he's sort of slightly lower down the food chain than I would have looked for an owner, for the various reasons that there might have been in that respect. So I just flagged that up there again. As I say, the application to have that struck out was dismissed on the back of the evidential pleadings. I will then just mention issue estoppel in just 2 minutes, if I may. That's the principle, just to remind everybody, the principle that even where the cause of action is not the same in the later action as it was in the earlier action, if some issue which is necessarily common to both was decided on the earlier occasion, the earlier decision on that issue is binding on the parties. So had there been these earlier decisions in that sense. And it was, of course, as one would imagine, examined in some depth. And I'll skip straight through to the findings. It was found that there was, in fact, an issue of estoppel, and it was disposed of on that basis. The decision on negligence, this was the decision within the previous arbitration award, was necessary to decide the preliminary issues. So one would need to understand how the pleadings in that went made. But when you looked at the award that the arbitrators had made, it was quite clear what it was that they were doing. It was the partial final award. It dealt with what it was that they were dealing with. They find, hold, and declare, and it was final as to the matters determined therein. And that begs the question of what were the matters, but that was dealt with within the judgment. And so essentially it did what was said on the tin, and it was final as for the things that it had determined, and it had determined that the MSC were not negligent in that respect. And therefore it had been decided. The main conclusion, then, just to summarise, is on that, and this is the point I think in relation to anti-suit injunctions, is that steps can be taken to enforce a judgment obtained before the limitation action is finally determined. And I query whether, when it was perceived to be a difficulty, why that wouldn't apply even after it's been determined, on the basis that if you haven't made a claim against the fund, other than challenge certain aspects of it, that you would then be barred under Article 13. And also, if the owner has settled a claim prior to that claim being made against the fund, why he would be entitled to bring that claim against the fund subsequently. So those were both the conclusions of the judge and some of mine, I'm afraid, for what that is. So thank you very much for listening. I think we're...
Thank you very much, Richard. What I'm going to invite us in the room to do, and by whatever means watching online you might join in, is reserve any vote of thanks in the traditional fashion until we've grilled them a little bit to make them work that little bit even harder for their drinks and nibbles, which I think I can see with shadows in the background are being assembled even as we speak. So let us be efficient with our questions. I would offer this observation only, which I think I can offer, given that it is an aspect of the Article 4 defence which I dismissed. I suspect, Richard, that on your query as to whether the concession that the head of MSC's dangerous cargo department might be a sufficiently senior individual for the purposes of the Article 4 defence had a substantial procedural tactical aspect to it, may well be right. Because it was conceded before me, I did not have to deal with it in any detail. I will certainly say that there appeared to be a range of evidence concerning the degree to which that individual had a level of autonomy and control over the function of MSC's safety procedures, that one can see how, in the context of an attempt to knock something out as effectively a strikeout or summary judgment application, a view might be taken that, well, we think we will win that point at a trial, but it's going to be a difficult one to persuade a judge to cut through on a summary assessment. That isn't to say necessarily that after a trial one would have decided against that individual being senior enough. One just doesn't know how the full evidence would have come out, but one can certainly see how the dynamics of a summary assessment type of hearing, a strikeout or summary judgment, as distinct from a trial, may well have come into play. I'm going to kick off the question and answer with one question from an attendee online for Chirag, picking up, I think, the observation that in the Court of Appeal, that in concept there could be more than one operator. It is pointed out or suggested that typical ship management contractual arrangements can allow three different businesses, so three different corporate entities, to be appointed commercial, technical, and crewing managers, respectively. And the questioner notes that we're told by the decision that merely being involved in the supply of crew, so a crewing agency, for example, would not be sufficient to constitute you an operator. But they ask provocatively if the group had so arranged things that Stemma UK did not merely de facto do the things they did when the barge was in Dover, but had, I'm paraphrasing the question, but had a shipman contract naming them as crew manager for the barge, or co-crew manager for the barge, I add, since they would be actually in charge of effective crew operations for part of the time. Might the limitation issue have been answered differently, do you think? Or is that all for another day?
Well, no, I mean, it would be an interesting case for another day. The thing to remember about the facts of this case is Stemma UK's involvement, albeit they did provide the crew, was temporarily very limited. So it was limited to 14 days. Now, if Stemma UK had been providing the crew at every place that the vessel went, then perhaps different arguments might have arisen. I mean, one of the points I made is if Stemma UK is the operator of Dover, then every port that the Stemma barge goes to, it has a different operator because it's a dumb barge, it has no crew. So wherever it goes, somebody else will be providing the crew. It may well be the buyer, as it was in this case. So every buyer becomes an operator. And when you look at the limitation convention, and particularly if you read the Travaux Préparatoires, there are so many attempts to increase the scope of people who are entitled to limit. And then, people are just sort of throwing the book down. No, this is exceptional. We're not going to extend it. So, the idea that the judge had is, oh, well, they're related, it promotes a commercial. And that isn't the way that the parties to the convention were thinking, right? They were thinking, we want this very limited. And every now and then, one country would come in and say, oh, let's just extend it a little bit. And people would talk about it and they said, no. So,
but which means, as of course, as a former mathematician, I would say I like about case law discussion. It's always important to focus on exactly what has been decided.
yes,
And in any case where what has been decided is that on these facts, the answer is no.
yes,
There's always a limited extent to which that same judgment, as a decision or a precedent, therefore, can be authoritative as to what would have been sufficient to get to the answer, yes.
yes,
We have the concept that one cannot say never to the idea of multiple operators,
Yes.
but exactly what sets of facts might generate a positive answer in a particular case will be
Yes.
for another day. We'll see if a case arises. Thank
That's
you
right.
very much. The other question, since there were two and they were both good questions, I'm going to take them both before throwing matters open to the room here. The other question online relates to Richard's presentation and is this. Picking up your Article 12 comments, I think, Richard, the question is, if an owner settles a third-party claim and seeks to claim against its own fund, claiming to be subrogated, who assesses whether the owner's settlement was reasonable? The suggestion being it could be a means to manipulate or exhaust the fund to the detriment of other creditors, the sort of thing that in what is in a way a quasi liquidation, is it not? After all, what we do by limitation is we let the ship carry on trading and say, here, have this fund, and then we're almost as if we're an insolvency court then proving claims against what is now a fixed and realized asset, but without in fact rendering the ship, as it were, bankrupt. So who gets to police the reasonableness of an owner seeking to put itself in the position of a subrogated claimant against its own fund?
Well, I think you do. Is this probably the short answer? The longer answer, I guess, is, and I think I'm going to get this right, is that if there are, let's assume that owners just turn up the fund and say, help yourselves, the various claimants against the fund, the defendants in the action, the claimants against the fund, can challenge other claimants and the quantum and the basis of those claims. And that would be on any number of grounds, it seems to me, including whether or not they have an entitlement generally under contract, or indeed whether or not the settlement prior to that has been reasonable. But I need to look at Article 12 to see, I think it says reasonably settled a claim against the fund. If it doesn't say that, then there's no obligation to be reasonable in any event. Well, on that assumption, that would be up to one or other of the claimants if they felt it was worth it. And sometimes if it's a small amount of money and there are a lot of claimants, might not be worth it. But if it was a large amount of money, and percentage-wise, it might be worth it. So that's the process as I understand it.
Thank you. Well, the correction to the short answer that it's me is probably in most cases it would in fact be the Admiralty Registrar, but that's a different point. That is to do with the management of the Admiralty list, in which of course I sit in charge of the list. I mean, as opposed to sitting in court, with the benefit of the work that the Admiralty Registrar does, and as a result, by and large, and except in the highest value cases, when one is then dealing with, as we do with collisions often in relation to assessing losses after liability has been fixed, if it is a matter then of vouching claims, checking the reasonableness of claims and making an assessment of all that, it is likely in practice to be the Admiralty Registrar in the first instance, although of course disgruntled litigants after decisions in front of him, if they think there are grounds for appeal, do have that right to appeal to me. So thank you very much for that answer, Richard, which has completed the two, but they were both good questions that I had received in the Q&A, at which point, and with at least a few minutes, I'm sure that we could spend, if there are questions in the room, before we adjourn for drinks. May I throw open to the room whether anybody had particular questions for any of our three speakers? And if you do, it might be helpful if you do identify before putting your question which of the three presentations sparked your question. Yes.
Richard, please. It was said that you can force a judge to get it within the collective communication fund. Does it mean you can only enforce the parts of the judgment for items which will not fall within the limitation, and not enforce in respect of there is liabilities which are for items which will be subject to limitation?
I'm going to obey Nick Austin's instruction before he had to leave us early, in fact, for another appointment, and just summarize and repeat, not because we didn't get it, but of course, so that those online know what the question is. So the question is picking up Richard's observation that it may be said the upshot of my decision on the anti-suit injunction application in the MSC Flaminia is that, at least as a starting point, a party with the benefit of a judgment or arbitration award on their underlying substantive claim may be free to seek to enforce that in jurisdictions where they perceive that enforcement may be available to them prior to the limitation issues, whatever they may be, having been resolved. So prior to, if the limitation action is in this court, this jurisdiction determining a limitation degree. The question is, does that observation apply only to such parts of the assumed judgment or award from another court or a tribunal that relate to unlimitable claims or items of loss or damage, or does it in principle apply whatever the limitability of the items that have made up the judgment or award?
Yeah, thanks. I think we're in new territory. If one thinks about the current situation with the Conti claims, nothing has been decided in limitation. So they will be claiming the full amount of their judgment in some local court and would expect to recover the full amount, subject to any arguments that might be made in local courts as regards the English limitation action. That seems pretty clear, and I think was the essence of the judgment here. If in fact then there are claims that are limitable, then I'm just wondering whether once that decision has been made, one has claimed against the fund in London, and therefore one would be barred in those circumstances from claiming the balance certainly you'd be barred from claiming the balance in some other state party to the convention, but possibly not in some other state that is not party to the convention. Does that help? I'm welcome for anyone to chip in and say that's complete and utter nonsense, or even that's only partially right, for which I'd be welcome.
For the twin reasons that were the question to arise whilst I am still the Admiralty judge, it probably will be for me to decide it, and that it's quite close now to the facts of the Flaminia and possibly what might or might not happen next in that case. I am certainly going to make no comment. I don't know whether Chirag or James wants to offer any thoughts or leave it with Richard's initial thoughts and move on.
I'm happy to leave it with Richard.
Very good. Any other questions in the room? I am not seeing any other hands go up, in which case, in Nick's absence, for which he apologizes, I say again, arising only because he had a clashing commitment, which meant he couldn't stay with us to the end. I've agreed to close proceedings, which I would normally ask him to do at the end. I hope that you in the room and you watching online may feel that the quality of the presentations mean that this evening has lived up to the expectation of the billing that I gave it at the start. Before I ask you to round things off in the room in the traditional manner to thank our speakers, may I specifically record all of our thanks to Reed Smith for the facilities, for what I hope has been smooth technology. I certainly have not been made aware of any glitches or concerns about those attending remotely, and most especially for the refreshments which those of us who are live will share, so that we can have a chance to catch up with each other a little in just a moment. So that thank you to Reed Smith having been done, the most important thank you is to our speakers, anyone attending a seminar of this kind may well be somebody that has spoken from time to time at similar seminars. So you all know, I know how much work goes into making sure that a presentation is polished and informative and of quality, such as the presentations we have been had the pleasure to receive this evening. If you would please, in the traditional fashion, record our thanks to our speakers. I'll therefore bring this evening's proceedings to a close. Thank you very much, gentlemen.
And I should say thank you to the Honourable Mr. Justice Andrew Baker on behalf of all of us for being such a wonderful chair and keeping us all in order.
Very kind.